So it looks like we don't have a question. So we're gonna start with tested succession. We're gonna start with tested succession, and you're gonna get questions on tested succession. That is a very obvious um, thing that you're going to find tested succession in that exam, and that is a question to do with wills. Okay. Now, what I want us to do today is number one. Sorry. Number one, what we're going to do is we're going to have a conversation. We're going to have a conversation around the law of probate, just to crystallize a few things, because I also understand that some of us, we are coming from different backgrounds and different trainings and different jurisprudential exposures. So the only thing that will clarify a few things is what the law says. That is the Law of Succession Act. Okay. So I want us to walk through and try and clarify a few issues around the law of probate so that at the end of the day, you know the question to do with the law of succession. Now, there are two things you need to understand. The first one is the general probate process, the process of getting probate. That is the process of getting a grant. Where do you start from and where do you end at? Okay, that is the first thing you need to understand. Number two, you need to understand the three categories or the three sections of probate. That is the question of intestacy, testacy, and grants. That is all you need to understand. Once you understand that, then the question is going to be very easy for you. The other thing you need to understand is the parties in probate. Parties in probate are very, very important because all the questions in that exam are going to be about the parties. Parties, parties, parties. Okay? In terms of drafting, there are a few things you can be told to draft in a probate exam. The first one is a will. It was set in the last exam. I'm not very sure whether they can set it again, but it doesn't hurt. Just trying to figure out how a will is supposed to look like. So that is a will. Second thing that you might, or high chances you're going to find in an exam, is the drafting. That is drafting the grants, the petition for grants. Yeah. So you're going to find one of them, or you may find one, which is how then do you petition for letters of grants? Again, that is something that we've gone through. You might also want to look at that as well. Apart from that, you might also want to know how to prepare legal opinions, also on the various issues that we'll discuss. Okay. Now, legal opinions are just the obvious things that we draft all from CIVO, LWD in all the units. The legal opinion doesn't change. Are we together? So please, please, please have an open mind in as far as this unit is concerned, and then we can all get down to business and pass. This is one unit that is very, very simple. Okay. All right. Or as we do this unit as well, it is important to note that always stick with the law and avoid emotions. One of the things that this is one unit that people will do, and they're very, very emotional. You know, they're very, very emotional, and you're wondering why this person crying. Somebody will be sitting the exam, and they're sitting next to you, and they're crying. And you're wondering what is happening here. So it's not real, guys. It is just a story in an exam. It's not a real story. So don't be emotional about it. Okay. So that is that. Also, you have different experiences with this question of probate. So you want to put those differences aside also as well. So there are certain things, experiences that you've had that has shaped your ideas about certain things. Okay. Also in questions of dependency, questions of presumption of marriage, and all that. So please, please make sure that you put that away also as well. All right. So let's start with the question of parties. I want to start with parties, and then we shall talk about the question to do with tested succession, and then we go to intestacy, and then grants. Are we together? So that is the drum roll for our discussion today. And I will expect you guys to please make sure that your microphones are muted. If you have a question, put up your hand, ask the question. and we shall help one another. Okay, so that is that. Confirm you can hear me so that we can start.
Yes, we can, Mwalimu.
All right, that is fine. Now let's start with the question of dependence. And the reason why I'm starting with dependence is because I've realized, not even realizing, if you go through all the questions, the majority of them is about dependence, whether somebody is supposed to inherit or whether a property is supposed to move or not. That is the question of dependence. That is one thing you need to have at the back of your mind at all times. Now, when you look at Section 29 of the Act, it defines who dependents are. It is very important before you start on anything probate, you must understand the dependents. You must understand the dependents. Are we together? Who the dependents are. Okay. Now, the first person you need to understand, which is very controversial, is the person called the wife. So, who is a wife within the meaning or within the scope of the act? Who is defined as the wife? Very, very important. There are three people that normally will be regarded as the wife. There are three categories of people that will be regarded as wives. Are we together? So, who is the first person regarded as a wife? That is a wife that is married under the Marriage Act. So, that is the only time we are going to find the Marriage Act coming into the law of succession. That is when you're getting the meaning of a spouse, that is the meaning given to it under the Marriage Act. That is the 2021 amendment. Number two, the second person you can consider as a wife is the woman, which is, the woman, or let's say the wife coming from Otensawa and Jiko as public trustee. That is the cohabitee. Okay. Now, cohabitation is very live. Cohabitation is very, very important. Give me a second. 1 second, guys. Sorry. So, I was talking about cohabitation and I was mentioning that a cohabitee is a wife, okay? Is a wife under the marriage, sorry, under the Kenyan legal system, that is a common law. So the common law wife, okay, the common law wife is a wife. So if you are told that this person was cohabiting with the deceased person, then that person becomes a beneficiary to that estate as a common law wife. Okay, but also remember that when we have the first wife, we can't have the second wife, which is the cohabitee. A cohabitee cannot exist alongside another wife. What am I saying? You cannot have the first wife and then you have a second wife who is a cohabitee. Okay, unless, remember guys, unless the first wife was married under customary law. Why is that the case? When you look at the Supreme Court case decision on cohabitation in 2022, the Supreme Court said that a cohabitation can only lead to presumption of marriage if the man had the capacity to get married at that time. And that therefore means that this man was married under customary law, because if you get married under customary law, then you have the capacity to marry another wife again. And therefore, if you're married in the village, for instance, and you come to Nairobi and you cohabit with another lady for 20 years and give birth to a child, then that lady will only become a cohabitee or a common law wife if the first wife you married was married under customary law, because that is the only system of law that permits polygamy. Okay? If the first wife was married in church, then this lady will not fall under cohabitation, she will fall under section 3.5. I hope you're getting what I'm saying. So you cannot cohabit with somebody else if you're already married to someone else. Kama tunaelewana. So if you're married in church, married under statute, you cannot cohabit. Your cohabitation even if you cohabit for the rest of your life, 50, 60, 70 years, that will still be your your girlfriend or your boyfriend. Nothing much can come from that relationship. Are you together? Nothing can ever come from that relationship. Are we together? However, we are simply saying that this lady that you're cohabiting with for 20 years and giving birth to a child cannot come under the law of cohabitation. Okay? She can only come under Section 3.5 if you proceeded to marry them. I'm going to explain that. So we have the first wife, that is a wife that is married under church or under statute or under the customary law within the meaning of the Marriage Act. Secondly, we have the cohabitee, that is the woman that is married under the common law system from a presumption of marriage. Are we guys together? And then the third person that is considered as a wife is the woman under Section 3.5, that is the woman that is married under a system that permits polygamy at a time when the husband had already contracted a previous or a subsequent monogamous marriage. Are you guys together? So that is the third person we are regarding as a wife. Are we together? So at any point that somebody comes to you and they're claiming that they're the spouse of the deceased person, then you take them through the 3 steps. Are they married under the Marriage Act? Yes, then they become automatically a beneficiary. Number 2, if they're not married under the customary law, if they're not married under the Marriage Act or under any system that is recognized under the Marriage Act, then you take them through the rule in Otensai Wanjiku versus Public Trustee, which is the rule on cohabitation. Okay, if they don't meet that, then the last shot that they have is Section 3.5. Section 3.5 talks about the lady that is married. Guys, Section 3.5 is not about cohabitation. Section 3.5 doesn't support cohabitation. It doesn't recognize any element of cohabitation because the lady under cohabitation is not married. The lady under cohabitation is not married, and that is why we are presuming marriage. The lady under under cohabitation is not married. She is not married. The cohabitee is not married. It is only that you have lived for a long time. You've given birth to children, and you have investment and all the things. And then the public perception views you as husband and wife. So from that element of fact, we proceed and presume the marriage. But you're not married. However, the lady under Section 3.5 is actually married. This lady is married. Dowry was paid. A cohabitee is not married. So get the difference, guys. Don't confuse those two things. Those two people are not the same. They don't even link. Guys, are we together? Are we moving at the same pace?
Yes, Mwalimu.
Perfect. That is perfect. So let me explain Section 3.5 and indicate that for you to fall under Section 3.5, then there are two elements, or there are two things. The first one, you should be married. Okay, should be married. Number 2, actually there are 3. Number 2, you should be married under a system that permits polygamy. Okay, and then number 3, your husband must have contracted a previous monogamous marriage or a subsequent monogamous marriage. It means you are married, but this man that you're married to under customary law had been married before in church, or after they married you, they married someone else under statute, and therefore you become the woman under Section 3.5. Guys, are we together? So that must be very clear. So that therefore means if, let's say, Kamiri John, I'm assuming Kamiri John is married. Kamiri John, maybe I'm taking you out of the market. Are you married? I thought I saw Kamiri here. All right, so let's assume Kamiri is married. Kamiri is married under Christian, married under church, one wife. Kamiri comes to Nairobi, meets a beautiful lady, gets married again under let's say Kikuyu customary law. Okay, so Kamiri has 2 wives. The first wife is married under Christianity. Okay, the marriage under Christianity does not support polygamy. The marriage under Christianity, I mean, church marriages don't support the question of polygamy, and therefore some Kamiri marries another wife under Kikuyu customary law. Now, in this instance,
Exactly, and he is planning to do so.
Kamiri, what are you saying?
Kamiri is married under the statute, but given an opportunity, he will definitely go to section 3.5.
You're a madman, my friend. I hope your wife is, that is how people die. That is how people die.
We support him. We support Kamiri.
No, what the
Kamiri.
hell? No, what the hell?
Man, who be with man?
Kamiri, Sisi,
Yes, please.
we don't stay in your house. When your wife will be beating you up and pouring hot water on you, will not be there. So please watch your mouth. You will not sleep in that house. Please be very careful. So again, if your wife is listening, we are just using this as an example. We're not saying that Kamiri is going to get married again. We're just saying as an example. So we have said that if you marry under church and you marry again under customary law, then the one that you married under customary law is the woman under section 3.5, and that is because customary law does not support polygamy, and therefore the capacity question will come in, and therefore this second wife will be the woman under section 3.5. Are we together? Now, the flip of it is this, that Kamiri is not married. Kamiri marries under customary law, okay, comes to Nairobi, and then marries another lady under church or under statute. Now, in this instance, the first wife is the woman under section 3.5. Okay, the first wife is the woman under section 3.5. So this protection is given to the person who is married under customary law. Okay, why? Because Christian marriages and statutory marriages are deemed to be a little bit superior to customary marriages. Are we together? That is exactly what you're saying. So please, that is the instance. Now, let me give an example again and say that if Kamiri is married under church in Kabete AIC or Kabete, whichever church that Kamiri goes to, and after getting that marriage on, Kamiri comes to Nairobi, and then Kamiri cohabits with another lady for 10 years, gives birth to a child or children. They have investment together and all that. Now, in this scenario, there's only one wife, which is Kamiri's first wife, who was married under church. The second lady that Kamiri has cohabited with is just a girlfriend. You can be a girlfriend for 1 million years. Okay? The tag of a wife will not pass to this lady here. Why? She's not a lady, she's not a woman under section 3.5 because Kamiri is yet to marry her. Okay? Number two, she's not a cohabitee. Why? Because Kamiri is already married. Guys, we are saying you cannot become a cohabitee when somebody is already married. You're just a girlfriend. Are we together? When this guy is already married, there's nothing you can do in this world, even in the world after, that can make you a wife. Are we together? You can't do anything. You are just a girlfriend. So make sure you know the dynamics. If Kamiri is married in church, then the next person that Kamiri is cohabiting with is just a girlfriend. However, if Kamiri proceeds to marry that cohabitee, then that lady becomes a lady under section 3.5. So for you to fall under 3.5, you must be married. Okay? For you to fall under cohabitation, for you to be the wife under our Tensai Wanjiku versus public trustee, then your husband must be single. Okay? You cannot presume cohabitation. You cannot presume cohabitation with a man who is already married. Are we together? Also, if they're married under a system that doesn't permit polygamy. Guys, I hope that is clear, and I want us to go to the next concept, which is the question of a child. Are we together?
Quick question, Jackton.
Who is this?
Jamal, I've raised my hand.
All right, proceed and
On
ask your question.
paper.
Miss Omondi,
Okay.
somebody call Miss Omondi, please. Miss Omondi, mute your microphone. Yes, Jamal.
Yeah, so my understanding of Section 3.5 is the fact that it protects this woman and who is married under customary law, because there is no way that they can verify whether the husband is married, has contracted another marriage before the one that they want to be married to. But then, in the contrary, you will find that there is a possibility that this husband marries under the church, the Christian marriage, which is registered, but also again come and marry under, let's say, Islamic law, where it's potentially polygamous, but then it's also registered. Is this woman who was married under the Islamic law protected by Section 3.5 also? Because their marriage is also registered and customary marriage.
No. When it comes to the question of customary, marriages under Islamic law, it is purely within the Islamic law regime. This is very different. Marriages within the Islamic law are different, so they're not covered by this. This is only for Christian marriages, statutory marriages, and customary marriages. Are you together?
Yes, we are. Thank you.
Yes, so when it comes to question of succession of the estates of Muslim people or people that profess the Muslim faith, it is different, and that's why even their succession, you have to go to the Qadhi's court. So it's a very different legal system altogether. So because there are a lot of, in terms of marriages, there's a way that must be done. Even when we look at Article 24, that talks about limitation of rights. Article 24 talks about instances where that questions to do with succession, marriages in terms of Muslim law will be exempted from certain aspects of the Bill of Rights. Okay, so that is what we're saying. So when it comes to Muslim marriages, it is different. It's a different idea that must only be dealt with under the Muslim legal system, because that is now the Quran and everything else. So Jamal, if you are intending to do something the contrary of what the Quran is saying, abort the mission, please. All right, so let's I hope that is clear. I hope that is very well clear. Alice, last question, and then I can go to Alice, what is
Thank
your
you,
question?
Jackson. My question is, so you've defined three type of wives, and now the third one under three, the ones that let me just so that I get the question. 3.5 is a wife is number one, could be the one married under a church. The other one is a cohabitee. The third one under Section 3.5 is the one that is like a girlfriend. You can't say the husband is you can't say they are cohabiting because this man is already married. Yet, so she's just like a side chick. Is that maybe she can't be married? You can't say they are cohabiting, and also you can't say they are married under church. So they are just in a kind of like a side chick situation. Is that the definition of Section 3.5?
Sir, I'm not getting your question. What's your question? What is the question about? Can you maybe rephrase it again?
So my question under 3.5 is basically this man is not he is already married. Yes, yes. So the person he's with, they're not married. So you can only say that they are just in a side chick kind of situation. Is that's maybe
Section 3.5?
Yes, 3.5.
No. Section 3.5 is married, my friend. She's married. Okay? Section 3.5 is married. Are we moving together, guys? Because I think something's missing. Section 3.5 is a lady that is married. So why do we have Section 3.5? I explained this. I was just assuming that all of us are on the same page when it comes to Section 3.5. Why do we have Section 3.5? Where was Section 3.5 coming from? Where did this thing come from? Now, Section 3.5 is coming from Riogola, the Ruengis, and the Rubens Okamutua. You know those cases. Now, there used to be something under the old Marriage Act that was called capacity to get married. Okay? Capacity to get married. Now, that same thing, that thing is still under the existing Marriage Act now. Okay? Now, in that system, which is the old Marriage Act that was repealed in 2014, it used to say, okay, and it is still saying today, that no man shall marry under two systems of law. Okay? Which are these two systems of law? Church and polygamy, sorry, church and customary law, statute or customary law, sorry, and maybe church and statutory law. So you can't marry under two systems of law. That was the position within the old Marriage Act. You cannot marry under two systems of law. Okay? And therefore, it meant that if you get married under a system of law, for instance, as the statutory law or the statutory marriages, then you marry again under the Christian marriages, then the second marriage is null and void. Why? The capacity to get married. Because the moment you marry one wife under the statutory marriage, then you lose the capacity to marry any other wife. Okay? Now, that was the principle that used to exist in the old Marriage Act. Are we together? Now, what was the situation there? What was the mischief there? The mischief was this. Again, let me give another example. If you get married in church or under statute, you could not get married under the customary law again, because these two systems of law are polygamous. Sorry, they are monogamous marriages. So you can't marry again under another system of law, which is potentially polygamous. Now, because of that specific point, there was an issue. What was the issue? Because remember, Section 3.5 was placed there specifically to cure something. The original Law of Succession Act did not have Section 3.5. Section 3.5 was an amendment that was done to that specific provision. Okay. Now, what was this? What was the issue there? The issue there is men, Kenyan men, have been very, very consistent. They've never disappointed over the years. They would get married in the villages. They'd come to Nairobi. They realize that now they're beautiful women in Nairobi. They get married again in Nairobi. Okay. And then they will not disclose the fact that they are married in the village. Okay. They will not disclose the fact that they are married in the village. That is a point that they will never disclose. Okay. And then what will happen? What will happen is this: when they die, and of course, there's a way nature like punishing men. That men will lie and then they die fast. Okay. For whatever reason, men usually died fast. Okay. They will die fast. So when they die, then when the first wife who was left in the village would come for the body and everything that this guy owned in Nairobi or whichever town, then they'll meet a second wife. Okay. And you're like, who are you? This person is my husband. We've stayed here with him for 20 years. We have children. And this one will be saying, I'm the first wife. I've been married to this person. We have 5 children in the village. And then they'll go to court. Okay? They'll go to court. Each of them in their own right saying, I was married. This one is saying, I was married. Okay? Now, the first wife will be saying, I was married to this person first, and he married me. We have children and everything else. This is my marriage certificate. The second wife will be saying, no, I didn't know that this man was already married. I didn't know that he was married. I also married him. We have children. We have everything else. And then the court will say, quoting the same provision I've told you, that is the capacity to get married, the court will say, no, you as a second wife, you can't benefit because this marriage, unfortunately, was already married. Riogola, the lady, the second lady didn't inherit. Rirwenji, the second lady was told no. Rubens Yokamutua, the second lady was told no, you can't get anything because this man was already married. And because of the capacity to get married, he can't marry you again. So your second marriage, however long it took, it cannot be considered as marriage. Are we together? But your children are considered as his children. But you, as the lady, you are not his wife. Now, what happened with that? Now, there was that mischief because that never changed. Now, Parliament sat down and inserted Section 3.5. And what is the wording under Section 3.5? Very, very important. The first word of Section 3.5 is notwithstanding. Okay, now Section 3.5 is saying, notwithstanding the provision of any other written law, and that other written law was the provisions of the Marriage Act that prohibited second marriages in an instance of capacity. So it said it doesn't matter what the Marriage Act is saying on capacity to get married. Any lady that is married under a system that permits polygamy after their husband had contracted a previous or a subsequent monogamous marriage is nonetheless a wife for purposes of this act. And in fact, their children are also children. So that provision came to cure the mischief, so that after that, what case did we have? Irene? What is the case that that came after Ruben Njoga Mutua? Guys?
Irene Jerima Sharia.
Yes, Irene Jerima Share. So that is the case that now upheld Section 3.5, where the court now said, and the court sent a warning that, hey, you men, if you get married in the village under a system that doesn't permit polygamy, and you come to the city and you lie to another lady again that you're not married, and you marry them under the pretense of being single, and you die, remember they will be your wives. They'll be considered as your wives, and they will inherit your estate. Okay, so that was just a mischief that was cured to ensure that these women are not left stranded. Okay, the man that they've known all their life, they're now being told that you're not married to this man. That was that. So this lady is actually married, but she's married under a system that permits polygamy. She's not married under church, she's married under customary law. Are you together? So that is the woman under Section 3.5. Are we together? That is clear. Now, a cohabitee is the one I've already explained. So at what point do you become just a girlfriend? This is the point to become just a girlfriend. You become just a girlfriend if you are not married. Okay? Or if you are married under a system that doesn't permit polygamy. Okay? Like I said with Kamiri, Kamiri is married in church, then Kamiri comes and cohabits with another person for 30 years. That person that he has cohabited with 30 years is just a girlfriend, a side chick. Okay? He's not married to that lady. But if Kamiri marries this lady, then this lady will fall under 3.5. So for you to get under 3.5, then you must be married. I hope that is clear now. Are we together, guys? All right. So in terms of children, that is clear. The law is very clear on children. A child is a person that is married, sorry, that is born of the deceased person. Provided they're born alive, they become children of the deceased person. That is the first person. The child is any person that is born of the deceased person. It doesn't matter their age, gender, doesn't matter. Are you together? So that doesn't matter. Number two is any child that is adopted, legally adopted by the deceased person is the child. Because you know very well that adoption confers parental responsibility. Okay. Thirdly, the third person we consider as a child is a child that is taken in by the deceased person, and the deceased person provided for them during the time of their life. Okay, so that is the person we are calling the children that are taken in. So please mute. That is Joseph Musasizi. And somebody called Miss Omondi. Can the two of you mute your microphones? Joseph, mute. Miss Omondi, please. Thanks. All right. So children are clear. So the third child must show maintenance. That is a child that was taken in. They must show maintenance that they were being maintained by the deceased person prior to the death of the deceased person. So that is the child. So who else will fall under the question of a beneficiary? Of course, that will be the parents, step parents, grandparents, half sisters, half brothers, up to the 6th degree of consanguinity. So those are the beneficiaries, and those beneficiaries can only benefit in the priority. So the spouse and the children will inherit as a matter of right, and then others must show maintenance. Others must show maintenance. Okay, now who are other beneficiaries that we might have that are not part of the family? We have the former wives. Again, former wives are judicially separated. They are not divorcees. Divorcees are not former wives. A divorcee is just a divorcee. They are not even your relative. Okay, so they can't inherit from your estate. Only a person that is judicially separated can inherit from that estate. So those are the parties, guys. Please make sure you understand the parties. Now, apart from that, I want us to go straight and talk about the law of testate succession. So we start on testacy. So in terms of testacy, what is it that we first need to understand? So testacy deals with the question of wills. So the first thing you have to understand is what is a will. You need to understand the importance of making a will. I've been singing this song for a very long time. The importance of making a will. Why do people make wills? Okay. Why do people make wills? Is it a must you have to have a will? Okay. Is it a must that you must have a will? Why do people have wills? That is a very important question. Why is it important? Because you're going to get a question in an exam telling you that somebody has made a will or somebody is attempting to make a will. They have come to you. Okay. They have come to you and they're asking you, why should they have a will? Okay. Why should they have a will? Now, in that instance, that would be the importance of making a will or the significance of a will or why somebody should make a will. I hope that is clear. So again, I don't think that is something that needs interrogation in terms of discussion. That is something you can find out easily, importance of making a will. All right. Now, apart from that, apart from the importance of making a will, then you also need to understand now the actual process of drafting a will. We've gone through wills in this class. Drafting a will is not very, very hard in terms of framing. You just need to indicate the last will and testament of person XYZ. Okay, so what are the contents of a will? Number one, you will have your beneficiaries, you will have your assets, you'll have your liabilities, you'll have your what do you call it? You'll have your executors. Okay, and then you might have directions in terms of how your body should be disposed of, and then you'll have the questions to do with the signing and the dating, and then you'll have your witnesses. Making a will is very simple. Don't write a lot of things. Don't write a lot of things. Just know what goes into a will. The first one that goes to a will is the question of your beneficiaries. Who are your beneficiaries? You have to indicate your beneficiaries in terms of your wife or your husband and your children or any person that you want to inherit from that estate. That is number one. Number two, you are going to have your assets and liabilities, all the things that you own and your liabilities. You're going to have that as well. After that, you're going to have now the distribution in terms of who gets what goes to who. That is distribution. After that, you're going to have your executors. Who is this that is appointed to execute that will? Who will be entitled to execute the will? Okay, that is the executors. And then, of course, you can have you could appoint even a guardian in that will. It depends on what the testator is giving you. Okay, you are going to have the question to do with disposal of your body. Should that be important? Again, the examiner will tell you that this person wants to be cremated, whatever. That will be there in the question depending on the directions. So when somebody is making a will and the examiner gives you like the same instance that was given in the last exam, you just copy paste that word for word and put it in a will. Okay, but of course you need to indicate that this is the last will and testament of this person. Okay, a will must be dated. You must have witnesses as well for attestation and execution. I hope that is clear now. So that is the question of making a will. Now, aside from making a will, let us now talk about making of a valid will. So that's a question that never misses in any exam. How do you make a valid will? What goes into a valid will? What is this that is supposed to go to into a valid will? Okay. What is it that is supposed to go into a valid will? There are three things that should go into a valid will. What is the first one? The first one is the question of capacity. Okay. The second thing is the formal requirements. And the third thing are vitiating factors. So capacity, age, and mental capacity. That is Banks versus Goodfellow. We know that case very well in terms of what goes into a valid will, in terms of age and mental capacity. Banks versus Goodfellow. That is a locus classicus case. So the person must be above the age of 18 and must be mentally stable. What is the difference? What is the exception to the rule? Okay, what is the exception to that rule? Okay, so the first exception to the rule is this. When it comes to age, a person that is below the age of 18 can make a will, but re-execute the will when they turn to the age of 18. They re-execute a will when they turn to the age of the age of 18. That is the first exception when it comes to the question of age. What is the exception when it comes to the rule on mental capacity? The exception is very, very simple. Okay, number one, the question of lucid moments. A person that is mentally unstable can still make a will, provided that will is made during their lucid moment. So those are the rules you need to understand, guys. They're not very complicated, though I must warn you, you're going to find a very long question, long and boring. Okay, time is a factor when it comes to probate as well. Okay, time is a factor, guys. Again, let me tell you something. I think most of you have met this maybe in an exam. An examiner will tell you that 1 + 1, please complete the following calculation. 1 + 1 question mark. An examiner will say 10 marks. Some of you will start wondering, how do I get the 10 marks? Just write 2 and you get your 10 marks. The marks allocated has nothing to do with the answer. Are we guys together? So don't, if you find a question that you know the answer very well, but you're wondering how many marks is this thing? So if 1 + 1 is the question, the answer is 2. Okay, there's nothing else. The answer is 2. So even if it's 1 million marks, that is that. So don't start there and say, oh, I think this is the wrong one, or I don't have enough words. No. When you go to the exam, guys, just answer what you have. Just go direct to the point, answer it, you will pass. No question asked. Are we together? So don't question yourself and say, oh, this thing was 10 marks, but I only wrote 2 lines. You are still on the good end. So that must be clear from the word go. Okay. So please make sure that is okay. All right. So let's go to something else. That's something else that I want us to. Can you hear me? Yes. Let us go to something else, and the something else that I want us to go to is the question to do with the formal requirements. In terms of formal requirements, there are 2 main formal requirements. Can you hear me, guys?
Yes, doctor. We can hear you.
All right. Sawa. So the formal requirements, there are 2. The first one is execution, and the second one is attestation. So what is the rule when it comes to execution and attestation? What is the rule when it comes to execution and attestation? So the first execution is the will must be executed by the testator himself. Okay, the executor must execute the will himself. If he doesn't execute the will, that will is null and void. Okay. However, there are exceptions to that rule, or an instance where the testator will not make the will. Okay. In that instance, sorry, will not execute the will himself, where they are unable to execute the will. So that is done by, yes. Somebody is very happy. Miss Omondi, umefurahi sana. Siku yako ya kulea itafika tu, msijali. Your day of mourning shall come. And utalia vibaya sana. Can you mute your microphone, please? You shall cry, you know. Shalia mpaka huwezi lia tena. Yaani unasikia kulia lakini una nguvu ya kufungua mdomo. Yes, that is how you shall cry. You shall weep. You know, there's crying and there's weeping. If you have the energy to laugh now, please laugh. Please laugh. Give me 1 second. Give me 1 second. 1 second, please. Sorry. So execution, the general rule is that the testator must execute the rule. I mean the will himself. Number 2, if the testator is not able to execute the will himself, then the will be executed by somebody under the direction of the executor and before the executor. So under his direction and before him. He cannot go and execute the will at home and then bring back. No, he will execute the will there on behalf of the testator and under the direction of the testator. That is the simplest rule. After that, we have the question of attestation. So in terms of attestation, there are 2 witnesses. We have to have 2 competent witnesses. These are witness that is above the age of 18 and also mentally stable. So the rule. So a will must always be attested by at least 2 competent witnesses that must, attest the will before the testator. They have to attest, witness the testator signing, and also attest to that. So that is a very simple rule when it comes to the question of attestation. So they don't have to all be there at the same time, but each of them must be present when the testator is signing the will. Are we together? So it must be made before 2 witnesses. But in terms of the attestation, that like them signing the will, the will, they can do it at different times. Are we together, guys? So that is the question of attestation. However, also remember that there are certain instances where the testator will send an acknowledgement of his signature to them. So if the testator is not able, or if these witnesses are not present when the testator is signing the will, then the testator must send an acknowledgement of his signature to them for them to execute. Are we together? Yes? Mm-hmm. I can't hear you.
We're good. Good.
Yeah, we are together.
We're together, kabisa.
Okay. All right, sawa. That is clear. So apart from that, we have now an instance where witnesses are beneficiaries, where a will is executed by a witness who is also a beneficiary. Okay, what happens in that instance? What is supposed to happen in that instance? Now, remember that a beneficiary signing the will does not make the will invalid. Don't confuse that point. A beneficiary can sign the will, okay, as a witness, but the consequence of that is that that will, whatever is bequeathed to them in the will shall fail unless there are 2 or more 2 independent witnesses that have signed after them. That rule is very simple. I don't want us to overemphasize it, but it's very simple. What have I said? That a witness signing the will, a beneficiary signing the will as a witness is not a problem. Okay, that is not a problem at all. Are we together? But if the witness is also the beneficiary, then whatever is given to the witness shall fail unless there is another competent and independent witness that has signed the will after the witness. So that is clear to that. So please make sure you understand that as well. I hope that is clear, and let us go to something else. All right, any question? So that is all for formal requirements of the formal requirements of making a will. Formal requirements of making a valid will. The formal requirements of making a valid will. Now let us go to the vitiating factors. Now these vitiating factors are independent. They don't have to exist at all times. You can find an instance where the vitiating factors are not present. Okay, so what are the vitiating factors and how do they affect the will? So we have questions to do with mistake, certainty, knowledge and approval, undue influence, suspicious circumstance. Okay, now these are the vitiating factors. They will vitiate the validity of a will. For instance, if a will is made as a result of a mistake, then that will shall be invalid. Okay, the next one, if a will is made that is not certain, then that will shall be invalid for lack of certainty. Okay, or if a gift is made in a will and that gift is not certain, then the gift shall fail. And then lastly, sorry, the other one is the question of knowledge and approval. In terms of knowledge and approval, what are we saying? We are simply saying that when it comes to the making of the will, the testator must know and approve the contents of the will. The testator must know and approve the content of the will. Are we together? That is knowledge and approval. Undue influence is where the testator has been forced to make a will. They've been compelled, maybe under gunpoint or whatever. Okay, and that includes brainwashing. So the will shall fail because of undue influence. Okay, and then we have the question of fraud. If the will is forged or made as a result of a fraudulent action, then that will shall fail. Guys, are we together?
Yes, mwalimu.
Kitu kwa masikio ndo nisi. Are you there?
All right.
Okay.
Somebody's speaking.
No, it went silent, so I thought maybe I'm not the one who's not hearing you.
No, we can hear you as well. All right, so those are vitiating factors. Those are vitiating factors that you need to understand. Now, they affect the validity of the will, even though the will is made at a time when the person has capacity, or the formal requirements are adhered to, the will shall still be invalid if there is one of the vitiating factors. So that is as far as that goes. The next thing is the question of oral wills. Oral wills. Any question up to where we've reached? Somebody? Easy. Joseph, quickly, make it quick.
Thank you, Maldimo. My question takes you back, and I apologize for this, but I put my hand up earlier. The issue of this cohabiting lady for 20, 30 years, doesn't she have any remedy? Because, I mean, in law, someone must have a remedy either way. So, I mean, what
You
happened?
can have remedy in law, my friend. Remedy for what?
I mean, presumption of marriage. Yes, this guy has been married and she's lived with this guy and it can be presumed that she's married. does she go off empty-handed?
If you're not married, you're not married. There's cohabitation. There are things. There are factors you have to show. If you don't meet those factors, there's nothing like you're married. Okay.
So if she meets these factors, she would be considered to benefit from an estate, right?
I'm not getting your question. What is your question specifically?
My question was that, I mean, you stated that if a lady, even if she were to spend 100 or 1,000 years with a person, if this person had been married before, she wouldn't qualify for anything out of an estate. I mean, this is a scenario that can happen that would be brought to us probably in an exam. How do we go about this? I just need some advice.
She's a girlfriend. She's not a wife. She's not a wife. There's no cohabitation there. There's nothing she can do about that. If you're married to somebody, so if you cohabit with somebody that is already married, whether it is for 1,000 years, you're still just a girlfriend because capacity to get married, capacity to get, unless the first wife has died. Before that, you can't. Guys, there are conditions that must be met before you can presume marriage, and the Supreme Court has made that very clear. In addition to the factors in Otensai Wanjiku as public trustee, there's the question of capacity. At the time you are cohabiting, does this person have the capacity to get married? Are you together?
Yes, sir.
All right, so Onyango Lillian.
Thank you, Mwalimu. I'd like to seek clarification about the instance where a beneficiary signs a will as a witness. So after a beneficiary signs, do they need, I mean, is the requirement that 2 other witnesses sign or just 1 is sufficient?
Depends on how many beneficiaries have signed. So that normally the will must have 2 witnesses. So if the 2 witnesses are also beneficiaries, they need 2 more. If only 1 is a beneficiary, then they need 1 more. So it depends on how many have signed. Okay. But it doesn't mean that.
So just to get this clear, so for every beneficiary, they need to be sort of replaced by another witness. So if 1 beneficiary signs as a witness, there needs to be 2 other witnesses.
No, the rule is very simple. The rule is at any time, the will must be signed by 2 independent witnesses. Okay. The will should have 2 independent witnesses. So an independent witness is a witness that is not a beneficiary of that estate. He's not a beneficiary. So we are simply going to ask ourselves, out of this circumstance, if there are 2 there are 2 witnesses, but 1 is a beneficiary, what do we need to do to get to the threshold of 2 competent and independent witnesses? We need to add more person, who is not a beneficiary, because we already have 1 who is not a beneficiary. Now we add another one. Okay, but if both of them are 2, we need to get the extra 2. Okay, even if there are 10, all the 10 beneficiaries are witnesses to that will, we just need 2 competent independent witnesses to sign after them. So it doesn't mean that if 10 signed, we get 10. No, we are simply saying that the minimum is 2. So if 1 of them is a beneficiary, we add another 1. If both of them are beneficiaries, then we add other 2 that are competent and independent. Are we together?
Yes, thanks.
Okay. Lastly, Sandra.
I wanted to ask on the acknowledgement letter, when you said that the testator is not usually before the witnesses when they're signing. Now, when the witnesses are signing, do they also have to come and be before the testator?
Now the witnesses must see the testator signing, and if they don't see the testator signing, the testator will send an acknowledgement of his signature to them. Okay, the general rule is they should be present when the testator is signing so that they can witness that the testator signed. That is why you are a witness. You witness them signing. So he needs to sign before the 2 of you. Okay, and then after you witness, then you attest by signing. So in terms of attestation, as you are signing as a witness, you don't have to sign before him. You can sign later in time. However, the exception is if all of you are not there, then the testator must send an acknowledgement of the signature. So what is the meaning of that? For instance, if I sign a will right now and I have two witnesses that are not present with me, the reason why they need to be there, with me is because they need to see my signature being appended on the document. But if they're not there, I need to send them the document plus an acknowledgement of my signature, just to tell them that that signature on that document is my signature, because that is the only thing that will be missing if they're not there. Are you getting the point? So you only send an acknowledgement if they were not present when you were signing. Tunaelewana?
Okay, I'm not so sure if I'm getting it. After you send the acknowledgement letter, for example, the solicitor sends the acknowledgement letter. Now for the witnesses, then they just proceed and sign.
Yes, once you send the acknowledgement letter, then they sign. Why? It's not an acknowledgement letter. It's an acknowledgement of your signature.
Yes,
Not a
yes.
letter, just your signature that you probably you sign in a different piece of paper, and that paper is attached to the will, just to confirm that whatever is in the will is your signature. Now, why do they need to be present? The reason why they need to be present is they need to see you sign and see your signature. But because they were not there to see you sign, you send an acknowledgement of your signature to them so that they can confirm that indeed that signature that is placed there is your signature. Tunaelewana?
Yes, yes, thank you.
All right, sawa. Next is the question of oral wills. So in terms of oral wills, very clear. So we have the question of the validity of oral wills and proof of oral wills. Oral wills are valid if they're made. Of course, they'll be made orally, and they're made before two witnesses. Now, in this one, they don't have to be. They don't have to be independent. An oral will can be made right before the beneficiaries. Okay, so it doesn't require that the the witnesses be independent. So that is the validity of oral wills. Validity of oral wills. Are we together? So oral wills made, and then of course the witnesses are at least two competent witnesses. And then number two, in terms of validity as well, is that the period of death must be after 3 months. Within 3 months. So the testator must die before the lapse of the 3 months. So that is the question of validity. However, there's an exception to that rule. The exception to the rule of 3 months is privilege wills. These are wills that are made by members of the armed forces or the members of the merchant marine and their servants or their staff, and it is made at a time when they are in active service. It is made during the period of active service. That is the period they receive instructions of deployment until the day the deployment is done. Okay, that is when we shall have what you call the privileged will. So that is very simple. In terms of privileged wills, it is as simple as that. And then we have the proof of oral wills. Proof of oral wills. How do we prove oral wills? Of course, by the testimony of the two witnesses. Oral will is proved by the testimony of the two witnesses. So the two witnesses will come in and give their testimony in terms of what the testator said. Now, if the two witnesses are saying different things, then the oral will shall fail unless we can get a third witness to corroborate or support the position taken by the two witnesses. Are you together? So that is the question of proof of oral wills. Now, oral wills can also be made, can also be written down. Okay. For instance, the testator will be saying something, and that something will be written down in paper or on paper. Okay, so we'll write it down on paper. For instance, in Wambui Gikonyo and also Rufus Ngefe, you find that the testator was dictating something and the friends were writing that down. That is still an oral will. Still part of oral will is the question to do with audiovisuals and video wills. So audiovisuals or audio recordings as well as video wills are still regarded as oral wills because we still don't have a system. We don't have a system that really our legal system doesn't still recognize video wills. So all video wills, all audiovisuals will still be regarded as oral wills. So that is the question of oral wills. So oral wills, the question of validity before 2 witnesses, and must be the period of death must be within 3 months. And then in terms of proof, we are talking about the testimony of the 2 witnesses, who will then testify as to the intentions or the words of the testator. Tuko salama? Obongo Saka. Obonyo, can you mute your microphone? Guys, are we together? Is that clear?
Yes.
Okay, so I can't see any worries about that. So let's go to the question to do with revocation of wills. So in terms of revocation of wills, what do you need to understand? In terms of revocation, a will can be revoked. A will can be revoked by the maker, that is the testator. A will can be revoked by the maker. Any person that makes a will can revoke the will. Any person that makes a will can revoke a will. That is something that you also need to understand. Any person that makes a will can revoke a will. Okay. Now remember that the testator is the only person that can revoke his will. You can't revoke a testator's will. Okay. So in terms of revocation, what do you need to understand? You need to understand instances of revocation and then requirements of revocation. So in terms of requirements of revocation, again, for you to revoke a will, what is there? Sorry, what should be there for you to revoke a will? What is it that must be there for you to revoke a will? Number one is the same thing that was there when you made the will, which is the question of capacity. You must have the capacity. So you must be of sound mind for you to revoke a will. You must be of sound mind for you to revoke a will. You can't make a will when you're sound and then you revoke a will when you're not sound. So you have to be of sound mind when for you to revoke a will. Now, in terms of instances of revocation, number one, we have marriage. Okay. Apart from marriage, we have making another will or codicil. Okay, I will explain that. Apart from that, we have the question of destruction. Okay, destruction, of course, you know, that is a way of a will being revoked. We have loss when a will is lost. Again, that is a way of revoking a will. And then, of course, let's start from the question of marriage. Marriage is very simple, but people confuse this with divorce. Marriage will revoke a will, but divorce doesn't revoke a will. If you get married, there's a presumption that you will revoke the will and make, bequeath your estate or part of your estate to the people that you've married or to the kids that you'll get as a result of that marriage. That is the presumption. That is what the law presumes. Okay? That is what the law presumes, that when you get married, you will automatically be giving something to somebody, okay, that you've married. So that is why marriage will revoke a will, but divorce doesn't revoke a will. If you divorce somebody, it is between you and them to decide. Okay, because you are the testator, you decide whether you want to keep them in the will or you want to kick them out of your will. So divorce doesn't revoke a will. So please make sure you understand that as well. And then apart from that, is a question of making another will or codicil. So when it comes to making another will or codicil, we are simply saying that if you make another will, if you make another will, okay, then this new will shall be deemed to revoke the previous will if number one, they are inconsistent with each other, or number two, it expressly indicates that your previous wills are hereby revoked. Are we together? What is the meaning of that? So, if you make a will in January and you make another will in December, the will in December will revoke the will in January under two instances. The first one, they are inconsistent with each other. What is the meaning of inconsistent with each other? It means they are both talking about the same property. For instance, you bequeath a car to your daughter in January, the same car you bequeath it to your son in December. So the second one will automatically, that is implied revocation. The second one will, by implication, revoke, okay, the first one. And then secondly is where we have now the express revocation, whereby the second one in December clearly indicates that all the previous wills are hereby revoked. So guys, what is the take home there? Not all instances where somebody makes another will, the previous will shall be revoked. No, you as a person, you can even have 10 wills. You can make 10 wills. You can bequeath your cars in one will, your houses in another will, your piece of land in another will, your shares of money in the bank in another. So you can have as many wills as you want. But if the two wills are inconsistent with each other, it means they are contradicting each other, then the second will be deemed to have, revoke the first will. Or in an instance where you have two wills, the second will clear, even though they're not inconsistent or they don't contradict each other, the second will clearly indicates that all the previous wills are hereby revoked. Okay, that is that. And then we have the question of destruction. We have Rejones, Cheese versus Lovejoy, and then we have Resutherland. So in terms of Resutherland, what are we saying? Or in terms of all the cases we talk about, what is the main point there? Destruction and intention. So for you to destroy a will, for you to revoke a will by destruction, two things must be there. The first one is there must be all the destructions in the world. All the destruction in the world. Okay, that is number one. Number two, we are going to have what we call all the intentions in the world. What is the meaning of that? So if you're going to revoke a will by destruction, the will must be destroyed, completely destroyed. Okay, it must be destroyed to the point that you can't bring it back together. Okay, that is the first one. The second one is the question to do with intention. So you must have the intention. So if one is missing, the will is not revoked. Okay, now intention simply means that when that will is being destroyed, you had the intention. So Cheese versus Lovejoy, the person had the intention to revoke the will, but he didn't destroy. The question of Rejones was both the intention and both the destruction. Resutherland, there was a destruction, but there was no intention. So those two things must be there for you to claim that the will is revoked. That is destruction. Again, the last one is a question of where a will is lost. If the will is lost and we can't find it, we shall assume that the will was revoked by the testator before the testator died. So that is the question of loss. That is a presumption of revocation. So that is the question of revocation of wills. That is the question of revocation of wills. All right, no question on that end. So let's proceed to gifts. Gifts in a will. Again, this is very simple. Gifts in a will, very, very simple. What are we saying? What are we saying in terms of gifts in the will? Now, first, you need to understand the types of gifts that we have in a will. So remember, will is just a combination of gifts. It's just gift, 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 gift. Whatever is in the will is just gift, 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 gift. Okay? So we have different types of gifts. We have the testamentary gifts. These are gifts in the will. We have what we call gifts inter vivo. This is a gift that is given before the person dies. Okay. And then we have gift in contemplation of death. That is gift that is given in contemplation of death. So let's talk about the gifts in a will and make sure that you understand. So the first one is, of course, the specific gifts. In terms of specific gifts, this is a gift that is given to a specific person. My car shall go to my son. David. That is a specific gift. My car shall go to my son, David. That is a very specific gift. Okay, that is clear. Number two is what we are calling the class gift. Now, a class gift is a gift that is given to a class of people. My car shall go to my sons. So if you have two sons, then that is a gift that is made to a class of beneficiaries. Or my land in this place shall be sold, and the proceeds shall go to maybe the schooling of these kids in this village. So it is a class gift. Or my cousins shall live in this house. That is a class gift. So it's a gift that is made to a class of people. And then we have the residuary gift. A residuary gift is a gift that is made out of the residue of the estate. For instance, if I say that 10% of what remains shall go to my pastor, then that gift is a residuary gift. Or 10% of what remains shall go to my my grandmother. That is a residuary gift. So you're making a gift out of the residue. What is the residue? Is what remains after you bequeath. So you'll say, this will go to this, this person will take this person will take this, and this person will take this. And then person X will take 10% of what remains. That is so what remains is the residue of the estate. Okay, so 10% of it will go to someone, and that is a residuary gift. Okay, now in terms of gifts, again, let us talk about the principles or the doctrines around gifts. Now, these doctrines are very important, but again, the examiner will not come and tell you, will not put a billboard for you to tell you that this is now the doctrine of election, or this is now the doctrine of presumption of satisfaction, or this is now the doctrine of lapse. The examiner will never say that. Sorry. So that is the doctrine. So let's go through the doctrines. Let's go to the doctrines. Cherono, what is your question?
I wanted. I've noticed you've skipped this demonstrative gift. I saw it in. I think it's in the grants. Okay, in a certain question. I wanted you to elaborate on the fact that this is the type of gift that. I think the definition was if it is a gift that is paid out of a particular fund or property. But if that property is not there by the time the testator has died, it still has to be paid from the general estate. I really didn't understand that.
All right.
Yeah.
So again, we have a lot of terminology when it comes to gift. There are so many terminologies that you don't need to disturb yourself with. There's so many, you can't know all of them. Okay, depending on which jurisdiction or which text you're reading, you'll find a lot of classes of terminologies around gifts. So demonstrative gifts is a gift that is made from a specific property, but it is not specified. Okay, it is not specified. I don't know whether you're getting what I'm saying. The gift is not really specified that this is what my son will get. For instance, you are saying that each of my sons will get one car each. That is a repetition. Okay, you just say my sons will get one car each. Or upon my death, my cars will go to my sons. Okay, so you're not making a specific gift to a specific person. You're simply indicating that when you die, each of your sons will get a car. Okay, but you don't, you don't clearly indicate the specific car that will go to a specific person. Are you together? So that is a demonstrative gift. It's a gift that is you're making in an instance where the property, the property in question, the property covered by that gift is not specified. Are you together? That is what makes a demonstrative gift. Okay, You're just mentioning that this specific it comes from a class of assets. It comes from a specific source of asset, but you don't identify the specific property. For instance, you'll say that out of, I mean, my daughters will inherit the 10 acres of my the 10 acres of my I mean, each an acre of land, an acre of land. So if you have 30 acres and you have 3 daughters, or if you have 20 daughters, it depends. So we don't specify which land specifically goes to who. You're just saying, when I die, each acre will go to my sons. I mean, my daughters, for instance, in that question. So it is a demonstrative gift. But like I've said, there's so many. No examiner will be asking you that. Never say never, but no examiner will be asking you to describe that. But it's also good that you know. So it is one that is not, the property is not specified, even though the beneficiaries are specified. Okay. Or you say that upon my death, my sons will inherit my jewelry, for instance, or my household items. Even though you have identified the beneficiary, you have not identified the specific property that is supposed to go to them. Are we together, Cherono?
Yes. So it's just like a general gift, right?
Yes, it is.
I get you. Thanks.
Theophilus, what is the issue?
My question just comes from whatever you stated. And is it possible to bequeath household items or jewelry in a will?
Yes, you can. Who told you you can't?
I think I had it from some different source, perhaps.
Mm-hmm. What did they say?
This was a lecture class.
What did
One
they
of
say?
they said that you cannot bequeath household items or because I don't know, there's a little bit of contradiction. That's why I wanted to clarify. Because when you look at the law she was relying on, is in the case of intestacy, that they automatically devolve to the wife. That is that the household items or where they say 10% or the whatever the first 10% or 20,000. And actually, she asked us to find a case law on the same where somebody had, if we can find a case law on someone who has requested the household items, but we couldn't find any. So that's why I was seeking clarification.
Now, remember, again, the rules are different. You can bequeath anything you have in a will. Okay, you can bequeath even your watch, even your undergarments. You can bequeath them in a will. If they're expensive, if they're expensive, you can. However, when it comes to intestacy, where there is no will, then everything in the household will go to the surviving spouse. So that only happens in intestacy where you have a spouse. So everything you own, the personal and household effects will go to them. However, if it is testacy, you can bequeath that. There's no rule in testacy that says that you can't bequeath your watch or, let's say, your shoes. Okay? No rule that says that. Section 5, testamentary freedom. Every person has the testamentary freedom to bequeath whoever they want or dispose their property the way they want. Okay? And also ask yourself, Theophilus, what happens if they're not married? As a bachelor yourself, maybe you are, but I'm assuming you're not. If you have your personal and household effects and you're not married, can you make a will and bequeath them to someone? Yes, you can. So we can't say that your personal and household effects as Theophilus will go to your spouse. What if you're not married? That is the thing. So it's a clear thing. So when it comes to a will, guys, again, the rules that you are making reference to, for instance, somebody will tell you you can't bequeath personal and household effects, number one. Number two, you can also be told you can't bequeath animals or crops or agricultural land in a will? Yes, you can. It is only that if you don't make a will and these things land on intestacy, the rules are different. Okay, so the rules are different in intestacy. There's a way we deal with them in intestacy, but that does not extend to testacy, because in testacy there is a will to distribute them. I hope that is clear. So let's talk about the principles. I want somebody to explain the doctrine of election quickly. We can mention them as we go. Doctrine of election, somebody. Now these are doctrines, guys. These are doctrines or the principles that relate to gifts. So you'll not see them there. The examiner might ask you to discuss what what they mean. But in most instances, you'll just be given a scenario. And then from that scenario, you're supposed to deduce out which principle that is. And these principles only relate to where there's a will. Somebody tell me, what is the doctrine of election? Uh-huh. Or what is an instance that will raise the question of election? Guys, make it quick. Yes, Cherono.
This is where a testator bequeaths a gift that doesn't belong to him. For instance, he bequeaths a property that belongs to person A, and he gives it to the beneficiary B. So beneficiary A will be put to elect between accepting the disposition as it is, or to accept the disposition as it is, or he can decide to how do I put it, to practice his propriety rights and take back what belongs to him. And if he decides to take back what belongs to him from person B, he will be required to compensate person B with something small that the value would be at least almost the same with what he had been bequeathed by the testator.
Thank you very much. Yes, that is what it is. That is what it is. Somebody explain to me, what is the doctrine of ademption? Somebody, the doctrine of ademption, please. Come on, guys, we need to move with speed. Attention. Yes, Tamara.
It is where the property bequeathed in a will does no longer form the part of the estate, so that gift deems.
Yes, come again. Make it clear again.
I'm saying when there is a property that is bequeathed in a will by the deceased, and then by any chance the property does no longer form the part of the estate, maybe the property is sold, it was stolen or destroyed by fire, that property addems.
That property addems. That is the ademption. So ademption is very clear, guys. Ademption happens in an instance where the property doesn't form part of the estate at the point of the deceased person's death. That is ademption. The property, the gift shall adem. Somebody explain the doctrine of lapse. What is the doctrine of lapse? Yes, Alice Njuguna.
The doctrine of lapse now applies to the beneficiary who, even if he or she was gifted something in the will, the beneficiary is no longer existing, maybe dies before the testator.
Yes, what are the exceptions to the rule of lapse? What are the exceptions? Number one?
The first exception is where it's a class gift. The doctrine of lapse might persist because maybe not, I'm not sure how to explain that.
All right, let me explain quickly. Thank you. So the rule in lapse is that the moment you die, before the testator dies, then that gift shall lapse. Why? Because the will is only deemed to be valid upon the death of the testator. So the will is only regarded as valid upon the death of the testator. So if you die before the testator, then that gift shall lapse, except number one, a class gift, a gift that is made to a class of people. For instance, if it is a gift that was made to the sons, if one son dies, the gift will still exist for the remaining sons. Okay, the gift will still exist for the remaining sons. Are we together? So that is what we call the class gift. The second one is a gift that is made in satisfaction of an obligation. Satisfaction of an obligation. Okay, so that is, for instance, if you're making a gift to a creditor, to satisfy your debt, then that gift shall not lapse. Okay, number one. Number two, maybe it is child maintenance or wife payment, whatever you're paying, that is an obligation that you had. That gift will not lapse just because the person that you're making the gift to is dead. Okay, and then of course in this case again, where the beneficiary had an issue, that is a child, or leaves behind a child, then that gift shall go to the child. Okay, so those are the rules, or there are the exceptions to the rule of lapse. So the property sorry, the gift will not lapse in those three instances. All right, so I hope that is clear. Let us look at another principle or doctrine. That is the doctrine of presumption of satisfaction. The doctrine of presumption of satisfaction. How does this work? So in terms of the doctrine of presumption of satisfaction, we are simply assuming that where the deceased person or where the testator has bequeathed something, okay, the testator has bequeathed something to a beneficiary, to a creditor, and then that bequest is deemed to be in satisfaction, partial or full, of what was owed. So if you are a creditor and you've been given something in the will, then whatever you're given in the will is deemed to be in satisfaction of what you are owed. That the reason why the deceased person is giving you something in their will is because they owed you, and therefore they want to pay your debt. Okay, that is the doctrine of presumption of satisfaction. So we presume that this gift is made in satisfaction. Okay, so please make sure you understand that. So whatever is given to a creditor is mainly done so to offset what was owed. That is the principle of presumption of satisfaction. And then we have the doctrine of disclaimer and variation. This is where the beneficiary is not interested in whatever they are given. The beneficiary doesn't want whatever was given to them, so they are rejecting the gift that was given to them. Are we together? And that is the question to do with disclaimer and variation. So what is the difference in terms of disclaimer? You cannot refuse once you accept. Number two, you cannot accept half and refuse half. Number three, once you disclaim, you cannot decide who will benefit from that property that you rejected. Okay, that is disclaimer. For variation is the opposite. You can actually refuse even after accepting. And number two, when it comes to variation, you can always accept half. That is, if the deceased person gave you 30 acres, you can take 25 and leave 5, or you can take half of that 15 and reject 15. And of course, lastly, with variation, that you can decide who gets it. So it means if you reject it, you can tell the administrator or the executor that that portion that you rejected should go to person XYZ. So that is variation. So that is the question of doctrine. I mean, that is the question on variation and the question on disclaimer. So those are the principles when it comes to the gifts. The next thing that I want us to discuss right now quickly is the question of reasonable provisions, provision for dependents. Yes, Gerono, what is your question?
I had earlier asked you about the exceptions to elections. Are you able to explain? Because I can see one of them is creditors. I really didn't understand that, one of the exceptions to the doctrine of election. Creditors. So I wanted you to maybe elaborate on the same.
You are muted, Jackton.
Oh, sorry. So you're saying that I've never come across an exception to the rule of election. I've never come across an exception to the rule of election. Come again?
Yeah, it is actually. I actually saw it in the act, but they don't explain. They just say the first one is creditors. So I don't get how it comes about.
You know, I don't think.
Because let me just read it. It was saying exceptions to the doctrine of election is creditors, number one. Then number two, where the property does not belong to either the testator nor the beneficiary. Then three, where the property does not belong to the beneficiary at the time of the testator's death. And the last one was if the beneficiary indirectly benefits from the property being disposed by the testator.
I mean, those are clear from what you're reading. Like very clear. What is the condition there?
The only one that I wanted you to explain is creditors being an exception, but the rest is clear.
Now,
like
for that,
creditors
for
being
creditors,
an exception in what instance? Yeah.
For creditors, I'm not very sure. I won't lie to you. I'm not very sure how that becomes an exception to the rule of election, unless it is a gift that is made to a creditor. If it is a gift that is made to a creditor, in this instance, and maybe I'll try and look it up and give you an answer. I'll give you a definite answer after I look it up, but I don't. For this moment, I don't understand how creditors become an exception to the rule of the election. But I'll try and look it up and give you an answer.
Sawa, thanks.
All right. But for the rest of them, I mean, it just makes sense, because I don't even think those are exception to the rule, because those are if those things exist, then there's no election.
There's no election. Yeah, it's clear. The rest, but it's clear.
They're not really exception to the rule of election, because if those things exist, if the person, the property doesn't belong to the beneficiary, then there's no election there. So again, that's that one. But you get the point. So
yeah, I do.
Yeah.
I do.
All right.
Thanks.
Fanny, what is your question?
Okay, thank you. My question is with regards to the doctrine of redemption, where the testator bequeaths you a gift, and the gift, he replaces it with a similar gift. So he takes away the first one and then he gives you another. So does that mean that that gift redeems, or what's the position of that kind of gift?
Sorry, give us an example. I mean, that's what I'm asking. What is an example of that?
So I saw in a question paper, so there was this, I think it was a jewelry. So it was bequeathed to someone.
I mean, don't refer to the question paper. Just give me an example, but trace your question.
Okay. So for instance, you are given say a watch, and then the watch gets lost, and then the testator gives you another watch. So
which watch were you given in the first instance?
So the first watch got lost, so it doesn't exist. So basically what I'm asking, what kind of doctrine were they testing in that kind of question, and how can you approach it?
That is the question of redemption. Is redemption, because the property is not existing. It doesn't matter whether it is replaced. The property are deemed. If I give you a car today, I give you a car, a Toyota KBX number 123X, and that car gets involved in a road accident and it is written off, and I give you another car, the fact still remains that the first car that I gave you already redeemed. So whether you replace it or not, remember that gifts are specific things. It means I gave you something specific which is no longer there. So whether I'm giving you another one, that is another gift now. So replacing something, that doesn't mean that it is not redemption. It is a deeming for the fact that it is no longer there at the point the deceased person is dying. Okay? So whether they replaced it or not, the fact on the matter is the property are deemed. Tunaelewana?
Yes, thank you.
All right. All right, there's no question. So let's talk about provision for dependents. This I'll make it very simple and very quick. So in terms of provision for dependents, what is it that you must understand? In terms of provision for dependents, what is it that you must understand? Okay? What is it that you must understand in terms of provision for dependents? Very, again, simple. Number one is who is a dependent? Who is a dependent? Okay. Number two is how do you provide for dependence? That is what you have to understand. Very simple. So, number one, there's no right to inherit. There's no absolute right to inherit. You can't say that I must inherit. No, you don't have a right to inherit. Okay? The deceased person or the testator can always decide who is supposed to inherit from their estate. So you cannot decide that I must inherit. For whatever reason, for whatever happens, I must inherit. No, you can't. Okay? It is the deceased person, the owner of the property, who can decide who is supposed to inherit from their estate, and that they do within the will. Now, in an instance where the deceased person has left you out of their will, okay, then how are we supposed to provide for you? Because you might get a question like that. That is the question of provision for dependence. How do you provide for a dependent that was left out of the will? Okay, the first question is who are they dependents? Number one. Okay, the second thing is what they're supposed to do. Okay, the next thing is when they're supposed to do it. So who, what, and when. Those are the questions you need to ask yourself at any specific point. So who? A dependent is defined under section 29. That means the child, the wife, former wives or former wife, and number B, children that were taken in, grandparents, parents, stepchildren, step sisters, half brothers, half sisters, all those relatives. And then number C is the widower. Okay, that is a man who was left out or who was being provided for by the wife or the surviving spouse who is a man. Those are the dependents. Now, the first two classes of the dependents must show maintenance. That is, the child, sorry, must not show maintenance. They have the right to inherit from that estate as a matter of privilege. So they don't have to show maintenance. That is the child, and that is the wife, or the children, or the wives. Okay, they inherit as a matter of a privilege given to them under the law of succession. Okay, now that is the first one. The second one is the second category of people that must show maintenance. That is from the children that were taken in, the parents, grandparents, grandchildren, and all that. They have to show maintenance. Are we together? Now, that answers the question of who. The next thing is what they need to do. How do you provide for dependence? You make an application under Section 26. Okay, and this application is brought by, of course, a prescribed form under Rule 45. Rule 45 of the Probate and Administration Rules. That is the summons. So don't indicate the form number, just indicate you bring an application before the court in the prescribed form for reasonable provisions. That is what they're supposed to do. Okay. The next thing is when they do it. Now, this specific remedy is not available after the grant has been confirmed. So at any point you want, okay, to make an application for reasonable provisions before the court, the question is very simple. At what point are you making that application? It must be at a point when, okay, the grant is not confirmed. Because once the grant is confirmed, then the only thing you can do is revoke it. So this application must be brought before the confirmation of the grant. So that is the simplest of answers I can give when it comes to the question of provision for dependents. So who can make that application is the dependents as defined under Section 29. How do they make that application? In the prescribed form? And of course, they need to show, number one, that they're children or they're dependents. Okay, and I've already mentioned who will make this application when you're discussing the beneficiaries and the dependents, who was the wife, who was the child, and so on and so on and so forth. So that is clear as such. So again, once you make that application, the court will consider certain things. Under Section 28, the court considers certain things before you are given the reasonable provision. Number one, your financial status, the financial status of other beneficiaries. The court will look at your future and present needs. The court will look at the size of the deceased person's estate, your conduct in relation to the testator as well. What was the relationship between you and your dad or your mom, depending on who is making the will, or the reasons why the deceased person left you out of their will. So once the court has considered all those things, the court will make a decision under Section 27 to give you something, either a lump sum or a portion of that estate. That one must be very clear. So I hope you understand that as well. So that is a question to do with. With provision for dependence. Any question? There is no question. There is no question, so I'm assuming that all is fine. Yes, Tamara?
I have a question regarding Section 26. Is it any person, any dependent that can apply for that provision? Because I don't know the sources, but there's a difference between those who are not like fully provided for and not adequately provided for. So what is the position?
That is not provided for anywhere in law. The law only says that any person that is not adequately provided for, It doesn't mean whether you could be having something, but it is not adequate. You could be having nothing, it is not adequate. Okay, so any person, whether you have zero or you are given something small, doesn't matter. You go to court and make an application for reasonable provisions. Are we together?
Yes.
Yes, you can't you can't distinguish those two people. You can't say that if you have something. So what happens with somebody who has something? What do they do? What do they do? They can't do anything. So every person is covered under section 26. Okay, so either you have something or you don't have anything. You are all supposed to come under 26, under section 26 of the act. All right, so that is that. So let's talk about lastly in terms of wills. Second, lastly, is the question to do with properties that are excluded from the will. Properties that are excluded from the will. So this is the question to do with survivorship, nomination, and gifts in contemplation of death. That is donatio mortis, mortis causa. That is donatio mortis causa. That is the question of properties that are excluded from the will. They can't be in the will. So the first one is jointly owned property under joint ownership. That is any property that is jointly owned, it cannot be covered in the will, and therefore the law that is applicable, sorry, the rule applicable in an instance of joint ownership is the rule of survivorship, which means that the surviving joint owner will take the entire property. So any person that survives will take the property. So if you have a property that is owned by two people, person A and person B, and person A dies, the property goes all the way to person B without any form of succession. That is automatic transmission. It doesn't fall under the law of succession, and therefore you cannot even bequeath it in a will. That is the rule of survivorship. Okay. Secondly, in terms of the rule of survivorship, there are properties that are deemed to be automatically under survivorship. There are properties that are automatically deemed to be under survivorship or deemed to be jointly owned, and that is a matrimonial home. A matrimonial home is by law at any specific point deemed as a property under joint ownership. Okay, so in terms of survivorship, we also have the rule of comorientes, which is now the exception to the rule. So not the exception, brother. That is the presumption of survivorship. So comorientes is the presumption of survivorship. So when do we presume survivorship? Very simple. In an instance where, number one, two people have died in a scenario or a circumstance that we can't tell who died first and who died last. They have died in a circumstance that you cannot tell who died first and who died last. That is survivorship. That is survivorship. So for us to get out of that rule, or because remember, what is the rule of survivorship saying? The rule is saying that whoever survives must take the property. But in this scenario, we can't tell who died first and who died last. So in that scenario, we are going to presume survivorship. How do you presume survivorship? By comorientes. And what is the rule of comorientes? The younger person is deemed to have survived the elder person. Okay, the younger person is deemed to have survived the elder person. So if person A is 30 years of age and person B is 45, if they die in a circumstance that cannot make it clear who died first and who died last, then we shall assume that the younger person died last, and therefore the property will go to the surviving the estate of the younger person. Okay, that is clear. Lastly, in terms of commodientes as well, if the two people die in a circumstance that does not make it clear who died first and who died last, then in that instance we shall, and their spouses or they are a couple, then we assume that they all died at the same time. We assume that they all died at the same time, okay? And that is the spouse. And of course, the property that they owned shall go to the joint beneficiaries. So if they are spouses and they die at a time when we can't tell who died first and who died last, then that specific scenario would mean that they all died at the same time and the property shall go to their joint beneficiaries. That is the question of survivorship. In terms of nomination, it's very clear when somebody nominates somebody, then the property shall not be indicated in the will. The surviving person, so the person nominated will just obtain a death certificate, and then the property shall be transferred to their name as the result of nomination. And then gifts in contemplation of death, of course, you know the two rules. The first rule is the rule of danger. That is, there must be an imminent danger. Number two, there must be sickness, illness. So where there's no danger or illness, there is no gift in gift in contemplation of death. So if somebody says that after my death, my car, should I die, my car should go to Emmanuel. Okay? And they die. Now that is not a gift in contemplation of death if there was no danger or sickness. Now for you to make a gift in contemplation of death, you must, guys, you must be under danger or you must be under some illness. You must be sick or under some imminent danger. Without the danger or illness, if you say that should I die, my property should go to Isaac, then that is not a gift in contemplation of death. That gift will not pass under a gift in contemplation of death. Are we together? On the very least, it can only be considered as an oral will and not a gift in contemplation of death. Why? Because you have not met the threshold of danger or illness. Because for you to be contemplating death, you must be sick or you must be under some danger. That is when you can contemplate death. Okay, and of course you know the rules when it comes to gifts in contemplation of death. That is donation. The person must be given access to possession or access to the title. The person must have access to the title at all times before the death. So it means before you die, you must have given them means of access, either the key or a logbook or a title deed. You have given it to them. Okay, that is the first one. The next one is that when you're making a gift in contemplation of death, you are under sickness. You are under the danger or under some imminent illness or serious illness. The third rule is the question to do with you actually dying. You must actually die. For the gift to pass, you must die from either the illness or the danger or from any other cause, but before surviving the illness or the danger. What is the meaning of that? We're simply saying that if you had COVID, then and to give a gift in contemplation of death, then you must die. Die from what? Number one, die from that COVID. You must die from COVID. Or if you don't die from COVID, then you must die from something else before surviving COVID. Before that COVID takes you, something has taken. Before you, you get before you heal from this sickness, you died. So you must die from something else before surviving the sickness that you had. Okay, so you must actually die, and then you should not die out of suicide. If you commit suicide, that is the end of that story. The property shall not pass. So that is the properties that are exempted from wills. They can't be in a will at any specific point. Any gift that is made to that extent in a will shall be null and void, and it shall fail. It does not affect the validity of the will. It does not affect the validity of the will, but it does what? It affects the gift itself in the will. So the will still be valid, but that gift shall fail because it is a gift that is not supposed to be in the will. That is tested succession. The only thing that I will mention that you need to look at is the rules of interpretation of wills. How do we interpret wills? Rules of interpretations of wills. Questions as we adjourn? So tomorrow we shall look at grants as well as intestacy. There's a very short discussion, and then we shall complete and say hoya hoya. Go and see that paper. It's a very easy paper. I can tell you for sure. It is a very easy one. You're going to pass. Yes, Jamal?
Yes, okay. I'm seeking clarity on the properties that are exempted from being part of a will. When you were explaining about survivorship, you said survivorship, then you also included common interest. And my understanding is that with survivorship is where, let's say, me and you own a school, and I die, then the entire school automatically becomes your property. Hence, I cannot include it in my will, or it cannot form part of my estate. And in the doctrine of cum orientis, I still feel like it can still be part of a will. The only difference will be at the determination on because if it's in case of a school, the question would be if we both die in the same in let's say for example in a road accident, and me and you die in that same road accident, and it can who died first. Because I'm older than you, then the presumption will be I died first. So because you're the one who is still left alive, the will then now stands that the estate, the asset that I left it for you, can now pass. And like where we were saying that if the beneficiary dies before the testator, then the gift cannot.
Jamal, what are you saying? You're saying who is the beneficiary in this case? You've gone round and round and round.
Let me explain it again. There's Jackton and there's Jamal. In my understanding of the doctrine of cum orientis, is that Jackton and Jamal die in a road accident at the same time. And at this point, we cannot tell whom between the two died first. So the older person in that case will be presumed to have died first. So if I am the older person and I had written a will that I had gifted you an asset, then that asset will go to you or to your heirs. The
You're
reverse
confusing
is that
things, Jamal. When it comes to this question, you talk about there's no will. Survivorship, there's no will at all. Hakuna story ya will hapo. So you can't bequeath me anything in a will. You are I mean a joint owner as myself. We own it together. So you can't gift it to me. It's also mine. So this property cannot be in the will. So let me explain this and make it clear. The doctrine is survivorship. Okay? Where a property is jointly owned between two people or three people. Okay? Joint ownership. So the rule of survivorship means the person that survives the other takes the property. So in this case, if you die, I take your property. Okay? And then what is cum orientis? Cum orientis comes as a further point on survivorship where we are saying there are instances where we can't tell who died first and who died last. Now, in that instance, what can we do? We run to the doctrine of cum orientis. Okay? So you died and I died. okay, in a circumstance where we cannot tell who died first. Now, what will guide the court or what will guide the people remaining to know who will own the property? We all died in the same place at the same time, you know? So, what is the presumption in that sense? We need to presume survivorship, and that is the doctrine of comorientes. So in terms of comorientes, we are simply presuming that you, as the elder person, you died first, and then the younger person died last, and therefore the property will go to the person that died last, that is the younger person. So that is the doctrine of comorientes, which is just a presumption of survivorship. Okay, so in that instance, the property shall go to the estate of the younger person. Why? Because as per that rule, we are assuming that that person is the one that died last. Okay, tuko sawa jamaa?
Yes, perfect. Now I've understood. I was confusing now I've
Yes,
understood.
so
Yes.
in this instance, there's no will. Just know that in this instance, hakuna will hapa. There's no will at all. You can't put that in a will. You can't bequeath it to me in a will. All right. So that is that. Cherono?
Jackson, I ran across a question on alteration, and they had a lot of all the alteration. A certain alteration was made by a pencil, another one was made by a biro. It was not an ink pen, and it was not eligible. So I went back and did my research on a certain book that I've been reading, the one that I've been using to read the succession, but it's an old book. Now I came across a clarification for that answer, but I don't know if it's like the concept still stands as at now, because it's a 2015 book. So it says
Go
so
forward.
the alteration. Yeah, so now I know for an alteration to be valid, it has to be executed at the margin and witnessed by two witnesses. But now in this book it stated that further that for at some point an attested alteration can be valid if whatever the testator has cancelled out is not apparent, like it's not visible, then the alteration can be valid, whatever was added. Like if I cancel something, like if I cancel the word Ida, I cancel Ida and I put Jackton. If I cancel out completely the word Ida out of the will, then it will be like, it's like a presumption of alteration that Jackton is the new beneficiary. But if I just maybe I scrabble it, like I just cancel it out, but everyone can actually see that the name, obviously this is Ida, then it means that the alteration will not be valid, and the original wording will be taken as it is. So I wanted to clarify: is it possible for an attested alteration to be valid in that instance? If you're getting me, I don't know if you've gotten me.
Don't make things difficult for you. Don't go looking for trouble. Make it simple. Okay? And how do you make it simple? The question of alteration is very clear. Every alteration that is made before the will is executed doesn't require attestation. Any alteration that is made after the will is attested, must be signed again and must be attested by two witnesses. Okay, so any unattested alteration is null and void. That is the simplest rule. So just go with that rule. It makes life easier for you. So anytime you make an alteration, it must be attested to. So if it is a will, an alteration that is done at a time after the will was already executed. Okay, it means you already made a will, but you had some points to add, either through a biro or pencil, whichever way you wrote that. So that is the rule on alterations. All right, Ms. Omondi. Okay, she doesn't have a question, so we are going to adjourn the class there. I will see you guys tomorrow, same time, same place, 7 p.m. For intestacy and grants and asset account, the very small things, and then we can summarize the entire unit and say all the best to you guys and all that. Tomorrow at 2 p.m. we shall have LPM. Have a good night, guys. Take care of yourself. Don't drink and drive. See you. The recording has been stopped, so I will share it. I will inform you guys when